Hi, Nick Dogan, North State Law. We safeguard your professional license so you can get back to business. Today, we're going to talk about the complaint process with the Department of Insurance in North Carolina. So, whether you're an independent agent or if you're working for one of the large companies whose names I'm not going to say because I don't want to get in any trouble, but you know the ones, they've got either a flightless bird or some sort of lizard or some sort of military member in a hat or some other ones as well, but one of those. You're working for one of those, or you're working for yourself as an independent agent. You're behind the computer going through emails, and you get something from the Department of Insurance. You look through it, and sure enough, it is unfortunately a complaint. You can also be getting something in the mail, going through everything through snail mail, and open that envelope from the Department of Insurance. Sure enough, there's a complaint. So, like any other case, you want to be extremely careful at the outset of the complaint process with the Department of Insurance. And I would say even more so with some cases with the Department of Insurance because they do have a basically a criminal investigation division. So they're not going to be really open and honest with you regarding what they want to speak with you about. So you really want to be extra careful if an investigator from the Department of Insurance does talk to you. In my experience, most of the time, they don't really have these consultants. Sometimes they're called consultants. If it's a criminal investigation, they do go by investigator because they are law enforcement. But if DOI is doing a non-criminal investigation, most of the time they don't really reach out directly to the licensee unless there's an audit that's taken place. And an audit would be they're going through your financial records to make sure that your accounting is in order and things of that nature. Sometimes complaints can arise from an audit not lining up or not appearing to be up to snuff with the Department of Insurance. Other times you're going to get a complaint from a customer that feels like something was done wrong, and then like I said, it could be end up being a criminal matter. If it is a criminal matter, you want to be extremely careful and you want to invoke your rights, right to remain silent, right to an attorney, and you don't want to talk to the law enforcement officer. Now, you want to be clear to a law enforcement officer, and you want to be respectful and just say, hey, with all due respect, I'm in the process of getting an attorney. I invoke my right to remain silent, and I don't want to speak with you. At that point, they're not supposed to reach out again. Will they reach out again? It's possible, but they shouldn't. And you shouldn't agree to talk to them without an attorney present. And you should contact a criminal defense attorney and someone that does professional licensing as well to cover you on both sides of that. Okay. Now, just going back strictly to the complaint process with the Department of Insurance and what to expect there is you get the complaint, you read through it, you kind of have an understanding of what you're looking at. What you're also going to see is there'll be an informal conference document that says informal meeting ASD. And informal conference, we'll get to that in just a minute. But the ASD one, most people kind of scratch their heads on what's ASD? Agent Services or Division, yeah, Agent Services Division, and that's through the Department of Insurance. So that's going to be some sort of regulatory agent similar to an investigator. They don't specifically use the word investigator unless they're referring to somebody in law enforcement because they do have two divisions there. So, say you get that letter where it's informal conference ASD, they're actually going to give you a pretty decent amount of information in those. I will say sometimes the information ends up being a little bit light, but I would give them credit where credit is due and say of the type of agencies that I've dealt with in the past, and it's been a lot. They do a pretty decent job of giving you a pretty good, clear understanding of what they're alleging and what they're alleging that you violated. Like they'll list out there, the statute number and the statute, and then what you supposedly did to violate that statute based on their investigation. And then the next thing will be like an administrative code, maybe, and they'll list out that whole administrative code, everything in there, and then what you supposedly did to violate that. And it'll go down. It's going to be multiple pages most likely, but a lot of what I've seen in these informal conference documents, they're kind of repetitive. Like it would be one thing done, but there might be two codes that are supposedly violated from that one thing that was done, if that makes sense. So um, once you get that, you're going to be set for a date to meet with the Department of Insurance representatives at their office in Raleigh. They don't do these meetings virtually anymore. During COVID, they had done some virtual, and they just kind of stopped doing that. My experience with them has mostly been in person, and it's going to be their attorney representative, who is an attorney through the Department of Injustice, AG's office. They'll have a couple staff members, and then the person that has done pulled the records, done interviews and things like that. That person will be there as well. You're looking at about 4 people from DOI. That includes their attorney, yourself. If you have a counsel, that counsel will be present as well. So you all sit down and you kind of go over what they have as evidence. The biggest thing that if you believe that nothing was done wrong, you don't really have to say anything. You don't really have to present any evidence that you have or anything like that. You could save that for a contested hearing if you want. There's nothing wrong with that. And frankly, in some particular cases, that might be a good idea. On other cases, it could be a good opportunity to say, hey, I know that the information you guys have is X, Y, and Z. I was able to acquire this other piece of information. I got this document, or I got these affidavits from these other people. Here's this. This should satisfy anything that you believe was done wrong. Here's my proof showing that it wasn't done incorrectly. Let's kind of talk about this. Maybe that is enough to get them to kind of say, you know what, now that we have this other information, we're going to go ahead and dismiss this. That is a reasonable outcome. Whether that's to be expected or not, it really depends on the situation. But that is one thing. When you're exchanging information, you do it in the correct way and you have the right information that's going to counteract the information that they have. You might be able to nip it in the bud and be done with it sooner rather than later, not have to have a contested hearing. And there might be some other information that you acquire further on down the road after an informal conference, and you say, you know what? No, I didn't do anything wrong here. I'll keep working on getting information. You request a hearing, and then at that point, you could do two things. Similar to what I just mentioned, you can save that information for if you're going to the contested hearing. You can say, hey, I just got this info. Here it is to back it up, and you can provide it to them. Run a little bit of a risk there, because if they are flat out saying that they don't believe you, and in their minds that there's nothing that you can produce that's going to change it, then you've just given them information ahead of time instead of holding on to it closer to the hearing date. So it really does depend on what information you acquire, what you're accused of, things like that, regarding how you want to proceed, like into an informal conference and after an informal conference. Now, say everything goes pretty well in the informal conference, and say, well, let me back up a little bit. Say you don't really dispute what was done wrong, and you have taken corrective measures to ensure that something like that's not done again. And you also have a lot of documentation to back up. Hey, my office, we implemented these new policies, and we had these policies, but we did this updated training with staff, or we did this, that, and the other. Here's my proof. That's the time to bring it to the informal conference and say, hey, I'm sorry, I did this wrong. Here's what I did to correct it. And most importantly, keep it from happening again. And, did this harm the public? If it did, then here's what I did to make sure that that person was made whole. If it didn't, definitely point that out and say, look, I understand that there was a risk of harm to the public here, but nothing happened that harmed the public in this particular case. And I've done X, Y, and Z to keep something like this from happening again, so it doesn't potentially harm the public. So that's a lot of mitigation that you can do in those particular situations to potentially have the Department of Insurance come back and want to do a pretty light penalty. A lot of times when they're doing penalties, in my opinion, they come to a lot of extremes. It seems to me that it's either, I want a suspension or I want a fine. And there doesn't really seem to be a lot in between. And, I think some of that's the nature of the beast. They gotta, send it over to the registry if it's a voluntary settlement agreement, which I did a video on voluntary settlement agreements and got in the weeds on that pretty detailed. So check out that video whenever you got a minute. It's on the YouTube channel. Also have a blog post on it as well. But the voluntary settlement agreements, those are going to be sent over to the registry. It's going to be blasted out. If you're licensed in other states, you're going to have to report that to the other states that you're licensed, because they're going to eventually see it. So that in and of itself is, in my opinion, and I think I'm not alone in this opinion, a pretty substantial penalty. But what I mean with the Department of Insurance being like kind of far extremes, it's like, well, I want a suspension or a revocation or voluntary surrender of a license, or I'm going to implement this fine. And don't get me wrong, like nobody wants to pay money, but at the end of the day, when you compare the two, I'd rather pay a fine. I don't want my license taken. You can have my money. So you really have to, when you get a voluntary settlement agreement, you also want to, go through it with a fine tooth comb, because there's going to be certain things in there that you still dispute and think, this actually, it didn't happen like this. Yeah, I made a mistake, but it wasn't like it's written out. So there's some wiggle room there. There's always going to be some wiggle room with certain things, and you might have some wiggle room on the amount of fine that they're proposing that you pay. And, as it says in the first word, voluntary. You don't have to sign anything if you don't want. And that will lead us into requesting a hearing. You are more than welcome to request a hearing with not only the Department of Insurance, but any licensing authority. I did a video on essentially due process and a right to a hearing for licensees, where that comes from, and things like that. I swear it's not boring, so check it out as well. It's on the YouTube channel. It's actually pretty interesting information, very useful, kind of an understanding of where we as licensed professionals get the opportunity and the right to have a hearing in the first place. So encourage you to check that one out as well. So if you do request that hearing, there's going to be an opportunity for you to do like what's called formal discovery. You can request certain documentation that you might not already have. You can request, interrogatories, which are questions of, maybe investigator on a case or something like that. So you'll have access to those tools, and should help you strengthen your argument. Now, you might have all that information and not need to do any discovery at all, but you have that as an option as well. And then obviously you're going to have enough time to get properly prepared for the case. You're going to be able to get your witnesses lined up, subpoena some people, and things like that, to make sure that you're set, you're ready to go, you're able to have a very strong defense, if possible, and kind of work through and hopefully in front of the hearing officer on your case, get a dismissal at that point. And there's always a possibility that, they're searching for a 2-year suspension. You have a hearing in front of a hearing officer, because I've had this happen before. You go in front of the hearing officer, they present their case, you present theirs, and say, look, this was a misunderstanding. Did I do something wrong? Yes. But does it warrant 2 years suspension or 12 months suspension? And the hearing officer said, you know what? You did do something wrong, but you did correct it. And I'm not going to do a year suspension. I'm going to do X, Y, or Z, which usually ends up being a fine. And then again, that's reported to, the registry, and, it is what it is at that point, but at least you have your license. So that's their process is actually pretty efficient, to be honest with you. There is some wait time with them for certain cases. I have noticed that audits happen to go a little bit faster than other cases. The ones that are usually a longer drawn out process are those that has the criminal investigation aspect in it, because they're investigators, being sworn law enforcement officers. They're not only having to deal with the licensing aspect of it, but they're dealing with the criminal court aspect of it. So that's why those are typically dragged out a lot longer. And in those particular cases, like I mentioned before, your freedom is worth more than anything, at least in my opinion. So you want to protect yourself on the criminal level and hire a very experienced criminal defense attorney, but you also want to protect your license. And that might be number two, but you still want to do that, because if you truly didn't do anything wrong, you want to be able to get back into work and being able to help the public out as much as you possibly can. So if you got any questions, please check out the blogs on my website, northstatelawfirm.com. Also, check out the other videos on North State Law's YouTube channel. And if you still can't find what you're looking for in either one of those spots, then please give my office a call or a text at 919-521-8810, and you get a free 15-minute discovery call with a member of my staff. Keep insuring North Carolina. Thank you all very much. Bye-bye.